this presentation on anti-money laundering regulation of attorneys in the Cayman Islands. The background to this is the Caribbean Financial Action Task Force mutual evaluation report. And one of the 63 recommendations in that is that in Cayman there will be a regulator for attorneys for AML purposes. So this is a presentation to deal with that and to deal with the response to that. And the organisation to whom responsibility has been delegated is CILPA. And within that, an organisation known as CARA, the Cayman Attorneys Regulation Authority, will take responsibility for AML supervision of attorneys. The legislative framework is set out in the slides, and the references there are to the anti-money laundering regulations and 55A and the regulations that follow. And the approach that will be taken very much mirrors that of the United Kingdom, where OPBAS, the Office for Professional Body Anti-Money Laundering Supervision, was set up some 18 months ago to ensure consistency across the piece in the AML supervision of lawyers, that is, solicitors and barristers in England and Wales, in Scotland and in Northern Ireland. And the OPBAS source book that formed evidence given to the Financial Action Task Force mutual evaluation of the United Kingdom clearly sets out that there should be a separation in governance between the representative arm, in this case CILPA, which represents attorneys, and any supervisory or regulatory arm of that body. And this very much mirrors the relationship between the Law Society of England and Wales and the Solicitors Regulation Authority in the UK on the solicitor side, or indeed on the barrister side, the division between the responsibilities of the Bar Council, or the General Council of Bar to give it its full name, and the Bar Standards Board. So this is a model that's been tried and tested and has formed part of the evidence given to the Financial Action Task Force last year in the United Kingdom. So what is the role of a supervisor? Well, this really breaks down into four parts. The first role of any anti-money laundering supervisor is to give guidance to its members. So the regime here anticipates that firms of attorneys, including sole practitioners, will be supervised. And so the supervised population is at one level, the firm or the sole practitioner. But of course, everyone will be conscious of the fact that there are attorneys within firms. And of course, guidance must be aimed at practical guidance to help members. So that's the first stage. And the guidance will be drafted and in due course will be put out for consultation amongst the supervised population. And this is very much the model of self-regulation, subject of course to the law locally, to other guidance that's relevant, and to any input that government may wish to have. So that's part one of what any supervisor does, guidance. The second part is supervision. So CARA will take a risk-based approach to supervision, and again will draw on the experience of those who've been through this process recently in the United Kingdom, and will draw on international standards again, such as the OPBAS source book. And in applying a risk-based approach, there'll be two parts to supervision. One of them is a desk-based review, where certain data will be looked at to establish where risk may lie, and then, if and when necessary, on-site visits, where firms will be visited in order to fully appreciate the risk-based approach that they are taking at their level. So that's very much the second stage. Having given guidance, this is what's required, there's supervision. And the third part of AML supervision is enforcement. For those who having been given guidance, having been supervised, are in a position where enforcement is necessary. There are avenues that can be taken by CARA, and to put it simply, very strong administrative fines can be brought in, and the system is robust and is there, and it is very much the mirror of the system that CIMA has. So there is the help under guidance, the supervision, which is ensuring people are complying, and then if that fails, and when that fails, enforcement action is taken. So that leaves the fourth part of the role of any AML supervisor, which is liaison with law enforcement. And that's not just locally. A supervisor must be equipped to deal with any confidential information that comes, as I say, locally from law enforcement or from perhaps whistleblowing, and must also be plugged into those international networks. So those are the four parts of supervision. Well, we'll move on now to what I hope will be some helpful suggestions about how attorneys and firms of attorneys in the Cayman Islands can respond to CFATF and respond to the recent changes in legislation here, which will lead to the formal regulation of attorneys. And the first distinction to make is between anti-money laundering regulations, which will very much be the focus of the rest of what I've got to say, on the one hand, and on the other hand, which we won't touch on so much today, the criminal law that sits there and affects everybody. So I've singled out there in the slides the proceeds of crime law, and obviously that still applies to everyone. So just by virtue of being here, of operating from the Cayman Islands, obviously the suspicious activity report provisions, the tipping off provisions, the money laundering offences themselves, there are criminal offences in respect of the proceeds of crime, and also in terms of dealing with terrorist finance, proliferation finance, and breaches of targeted financial sanctions. All of these sit within a bucket, if you like, of do not commit these crimes. So that is the criminal standard, and those are the criminal offences. But what we're focused on today is distinct from that. It's the anti-money laundering regulations, and obviously they sit there to ensure that there are policies and procedures in place which will mean that attorneys, in this case, and firms of attorneys, are not vulnerable to being unwittingly used by others who have criminal intent. So the first question which any firm will wish to ask itself is whether or not it is within scope of the anti-money laundering regulations. And the test there is whether or not the firm is doing RFB, or relevant financial business. And you may wish to look at Schedule 6 to the Proceeds of Crime Law. And if you scan down that, you will see lists of legal services which are within scope. So, for example, legal services relating to the sale, purchase or mortgage of land, or interest in land on behalf of clients or customers. Again, legal services relating to management of client money, securities or other assets. Legal services relating to the management of savings or security accounts, and legal services relating to the creation, operation or management of legal persons, or arrangements for buying and selling businesses and entities. So it's for each firm to look at that fundamental question: are you within scope of the anti-money laundering regulations? As I say, everyone is within scope of the criminal law. The judgment is whether or not you're in scope of RFB. And if you are, there are certain requirements upon you. The test is set out there in Schedule 6 to Proceeds of Crime Law, but you'll find your duties and responsibilities in the anti-money laundering regulations themselves. So just while we're on this middle bullet point on the slide, there is this duty of registration. So CARA will be in touch with firms asking them to fill in a registration form. And this really is for two purposes. It's obviously in everyone's interest that the Caribbean Financial Action Task Force recommendations are adhered to, and one of them is to have effective supervision of DNFBPs, designated non-financial bodies and professions, including attorneys. So we all have that motivation, and it's a strong one, to register who is within scope. And so the details that must be provided are set out in statute, and they are, as you would expect, information that identifies the entity that's within scope, whether that's a firm or a sole practitioner. But the view may have been taken that rather than bombard the supervised population with a number of questionnaires, it would make sense to reach out once and to also ask for a brief explanation of how it is that you say that you are within scope, if you are within scope. So there'll be a list of those Schedule 6 points that I set out. There will also be other questions on what will be a concise form which will enable CARA to discharge its risk-based approach. So there'll be questions in there which in one format will seek answers that can then be used for the next year, so that we all may apply a risk-based approach. And that's what's envisaged. So finally, and this is where I'll dwell at the end of this presentation, if you are within scope, what are your responsibilities? So as I say, these are found in the anti-money laundering regulations themselves. And you may or may not wish to, it's a matter for you, but you may think that Regulation 5 and Regulation 8 are good starting points. So Regulation 5 and Regulation 8 mean that you will have to have compliance programs and systems in place, but these are to be appropriate to the nature and size of your business. So it's not one size fits all, and you also have to do a risk-based approach and document that. But depending on the size of the business, that will mean that different businesses have, different firms have different levels of detail, very different client bases. And it has to be tailored to two things: the nature and size of the business, and of course the nature and size of the risk. So further guidance will be given, as I said, just harking back to that 4 stages of supervision. Guidance will be given as to how it is that those who are within scope can comply. And so, as I say, there will be a duty on some within scope to appoint money laundering reporting officers, anti-money laundering compliance officers, and deputy MLROs to cover. Everyone within scope will have to adopt what's called a risk-based approach, and we'll give guidance as to what that looks like. Some of you will be very familiar already with KYC, know your customer, know your client, with standard CDD, simplified DDD, and enhanced due diligence in the case, for example, of politically exposed persons. Again, there'll be more guidance provided. Well, thank you very much for listening.